SJC-11899, Marie Esler v. Mary Sylvia-Reardon, and another.
Thank you.
Good morning, Mr. Holtz.
Good morning, Your Honor. Good morning, Justices. My name is Herb Holtz, and I'm here with Tom Reed, representing the Massachusetts General Hospital and Mary Sylvia-Reardon. Judge Giles got it correct when she granted our motion for judgment notwithstanding the verdict. She did so based on several facts that she found, each independently fatal to Ms. Esler's claim. The court should therefore affirm that order, and it goes without saying that Judge Giles also granted in the alternative our request for a new trial.
How can you say that goes without saying? I mean, I read her opinion, and it seems to me she decided that you should be granted judgment NOV, and she didn't touch the, why would she touch the motion for new trial? Because she had just granted you judgment NOV.
The reason, Your Honor, I say it goes without saying is because embedded within that opinion, as well as at the front and at the actual end where the order is recited, she says she's granting a new trial in addition to the JNOV, and then it's also docketed twice as such. Your Honor, can I put it a different way? Because I think it's an interesting issue. The rule requires for a new trial that there be reasons given, that you can't just have a, as you would know, as a judge who ran her own trial session, you can't, for the purposes of appellate review, just do a margin endorsement. That's what the rule is trying to get away from. There needs to be a reasoned decision. There was an 11-page reasoned decision. Now, it coterminously dealt with both JNOV and new trial. But what Ms. Esler would urge this court to adopt is some sort of new standard that busy trial judges should stop in the middle of writing their own opinions, typing their own opinions with not a lot of resources, and what? Insert a whole new section into an opinion? Does that make it less or more of a reasoned opinion than what Judge Giles did? She offered, for all of us to see now, an 11-page reasoned decision, and she enumerated all the facts that she found were warranting both at a higher standard, JNOV, and at the lesser standard of sufficiency of evidence and probativeness of evidence. She found that a new trial was warranted. I may add also, and this court knows better than we do, that the standard for appellate review of a new trial is rarely do appellate courts find that the judge has abused his or her discretion. I think an appellate court used the famous phrase, a snowstorm in mid-May.
How do you know she granted a new trial?
How do we know? Well, it was docketed twice as such on this.
Counsel, it was docketed and also referred to in the motion just by the title, Memorandum of Decision and Order on Defendant's Motion for Judgment Notwithstanding the Verdict or in the Alternative for a New Trial. That's the way the memorandum reads.
Yes, Your Honor, but also at the end of the
As
memorandum.
well as the docket.
I'm sorry?
And the docket.
And the docket, correct. But also at the end of the same order that you're referring to, where the actual order is recited, it says, order allowing X and Y, grant allowed. So it's impossible to eliminate, to excise from that order the new trial. That's what the words mean. They're there.
Well, I don't think it's unreasonable for the appeals court to have concluded that a fair reading of the decision shows that the trial judge allowed only the request for JNOV and took no action on the alternative request for relief. I don't think that's an unreasonable reading of what we have in front of us.
Well, Your Honor, I would just urge the court to read again how Judge Giles, finally, after her opinion, captioned and encapsulated and recited the actual order she gave. And, you know,
5 minutes on this. Did you want to go to the...
yes, Your Honor. Thank you.
I assume that if you were not to prevail with regard to JNOV, that you would ask us to at least reach the issue of a new trial, even if we were to send it back to Judge Giles and say, did you ask for it?
Yes, Your Honor. Yes, Your Honor. The reasons that Judge Giles did enumerate in her order make it plain that even under the higher standard of a JNOV, there was no basis for the jury's verdict. each one of the reasons she enumerates, each one by itself would be fatal to Ms. Esler's case. They include a case built on self-contradictions, a case built on declarations that she cannot return to work, a case built on a failure to show any comparative evidence, even though that was what was promised to the trial judge, who happened also to be the summary judgment motion judge.
Can I just suggest that the tension, I think, is there is part of the basis for the termination was that the plaintiff could not perform all of the duties of a dialysis nurse. Isn't that right?
Yes, Your Honor. Well, and had declared her inability.
Well, and
To
that
come-
was the basis of needing to hire somebody who could perform all of the duties of a dialysis nurse, right?
Not quite, Your Honor.
Because the person who was hired couldn't do that for another several months.
True. Right.
So that's, I think, a point of some concern.
May I speak to it?
Please.
After Ms. Esler tells the employer that she cannot return to work, which is clear as a stop sign. That's what she says. And that's what Judge Giles found, and that's what the evidence is.
She couldn't
Could not,
return then.
on February 16th. She
Right.
couldn't return on February 16th.
As well, Your Honor, February 16th was an extension that had
Of the
nothing to do
family,
with the
yes.
FMLA. That was
Exactly.
post-FMLA.
She said she couldn't return as of the 16th.
And she couldn't return before that on the 6th, which was the end of FMLA.
I understand that, but
Right.
but she didn't say she couldn't return at all.
She said she could not return to work on the 16th. What she said was, I can come back in March, well after the FMLA now, with limitations. And here's the point to your question. Once an employee says under the FMLA, I can't come back, once that period of time expires, the royal coach does turn into a pumpkin. That's just the way this act is. We may not like it, but the rights drop out. The employer moves on. The pretext argument, which you're asking me about, is an odd overlay to this case. It's not the typical kind of pretext in an employment case. Pretext typically is something where an employer is trying to mask a bad act, and there are inconsistencies and shifting reasons. Here, the important distinction is once the employee's rights drop out, they have no rights. In order to prove retaliation at that point, on the footing of this case, they have to prove something else. Now, Esler actually articulated that exact paradigm. She said, there's something else post-FMLA that I have been deprived of. And in doing so, she really nicely articulated what she had to prove on the footing of these facts. Then she failed. Then there was no something else.
And what do you say she said that she had to prove and didn't?
She articulated at summary judgment, and Judge Giles said, you're barely getting through in this, but I'm going to give it to you, that there is a sole issue here, and that issue was that there was a clearance policy, a previously existing right that she was entitled to, and that the employer denied her.
But the appeals court said about that, you know, it's not, certainly without happening in the past, and it is permissible for the case as it proceeds to somewhat change form. So the fact that the trial was tried on something broader than that, or maybe not on that at all, and nobody complained about it, does it moot it out?
Well, I would say there's two answers to that question, Your Honor. First, the trial did proceed on that basis, and repeatedly through different stages, whether it was in directed verdict or the summary judgment before that or within the trial motions in limine, the issue was crystallized, articulated, re-articulated. Everybody knew this was the travel advisory. There was never any question. But secondly, even assuming that there was some sort of shifting or morphing within the case, there is no dispute that Esler still provided zero evidence on this something else, on this return to work clearance policy. She did not prove that there was any such policy. In fact, the only proof in the case was that a plaintiff an employee has to provide their own return to work clearance. That was the only evidence. Similarly, there was no comparative evidence. She said there were other nurses who were given the benefit of this policy, and they were returned to work similarly situated and they got light duty. Those comparators evaporated. She didn't call them. There was no evidence about them. In fact, let me just retract that one point. The only evidence about them came from the hospital, and it was that those two nurses were not similarly situated. One was a scheduler, one never came back to work. So the failure to show, as I keep calling it, the something else, post-FMLA, there has to be some other thing to form, on the footing of these facts, a retaliation case, and she failed to do it.
I read this over the weekend, so maybe I'm just not remembering, but I don't remember Judge Giles as deciding the JNOV on that basis, though, did she?
Well, that was one of the facts that she did decide the JNOV was.
Said that there wasn't evidence, but she didn't. She went on to say there was a whole lot of other problems.
That's true, and that's my point, Your Honor, is that any one of these factors destroys the case. One of the things Judge Giles focused on was the supervisor had engaged not in acts from which a reasonable inference of animus could be drawn, but she used the word salutary acts. For example, this same supervisor suggested FMLA, inquired with the employee about her status.
Isn't that a jury question, though? What the attitude of the supervisor was?
The adjective may be, but the empirical facts were undisputed, that she was the one who suggested the leave, gave 2 extensions, one of which was not even required by FMLA, and yet this same supervisor did it, gave FMLA to 6 other nurses, took FMLA herself. And Judge Giles, looking at that litany of unrebutted evidence, said, this is not the profile from which a reasonable inference of animus can be drawn. And she did, Your Honor. She did identify this litany of facts about the supervisor in conjunction with the other facts in the case. This is the $64 question in this case, whether once an employee announces their inability to come back to work, whether at the end of FMLA or even 10 days past on this gratuitous, not to use a pejorative word, but what I mean by it is a not required, an unrequired extension, also given by the supervisor. What happens then? How can we have a retaliation case on facts such as these?
Can we go back to the standard that Judge Giles was required to apply in this case? There's a way in which you can look at this and say that, well, that's her view of the evidence, but the jury found otherwise. That's problematic for you. If she gives the evidence a whole different cast from what the jury gave it, the jury obviously did not think it was important that Ms. Sylvia-Reardon had done all these wonderful things for Ms. Esler. So how is it that Judge Giles can decide that that's the deciding factor when the jury obviously didn't think so?
Well, that's a good question, Your Honor, and I would answer it this way. As you know better than I do, having been a trial judge, there has to be more than a scintilla of evidence. That's the standard under the JNOV. There must be more than a scintilla of evidence. And the jury sometimes gets it wrong, and the rules imbue in our trial judges the ability. The reason we have these rules is to allow the trial judge in a circumstance such as this to correct things and to give the judge the authority to do it, and this judge did it. This judge sat through not just the trial, but the summary judgment stage. She knew the facts. She observed the witnesses. And, Your Honor, it was not reasonable, plainly speaking, for that jury to draw negative inferences on these facts that did not lend themselves to those inferences. And sometimes that simply happens. And when it does, the rules are there for judges to step in and fix it. And she did so with a fairly well-enumerated opinion with factual analysis, not just adjectives.
That sounds like a motion for new trial standard. I mean, to correct when the jury's got it wrong?
Well,
like
there's 2
that?
standards, and they're cousins, perhaps. I'm not sure what the right word is. The standard for a new trial is not as high as a JNOV, as you know. Probative evidence, a sufficiency. It gives a fair amount of breadth to a trial judge who sees facts warranting a new trial. And as I said earlier, we know that on appellate review, it's rare to disturb those findings, those kinds of orders, which I would reiterate does exist here. On the JNOV standard, yes, Your Honor, it's higher. But on these facts here, as enumerated in multiple places and on multiple points, there simply was not a quantitative amount of evidence available to the jury to draw the inferences it did. And as I said, any one of these factors would destroy Esler's case. One example, saying I can return to work, she shifted strategies in the trial. All of a sudden she said, I can come back. But in trial, had to admit that she had testified to the opposite in multiple places.
She couldn't come back on February 16th.
I'm sorry, Your Honor?
That she couldn't come back on February 16th.
That's right. She said that in deposition. She said that in interrogatories that she never even addressed in the trial. They were left completely untouched. She said that her testimony was self-contradicted, and as this court knows better than we do, that cannot be the stuff to get a case past summary judgment, or in this case, past a directed verdict, or JNOV. Her case collapsed. Once she failed to show that something else, post-FMLA, she changed course and tried to say, no, 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 I could return to work. And the problem under her FMLA case, the problem was those facts about her inability to return to work were solid as concrete. She had to find a different construct. Post-FMLA, her rights had disappeared, they had dropped out. It is not fair to say the employer fired her or terminated her. The employer doesn't do anything. As I said before, the stagecoach turns into a pumpkin, or the royal coach, whatever it was. And after that, she had to identify something else that the employer did. She articulated it and then failed to show it. That's dispositive. That's why the judge was correct, Your Honor, in saying that there was not a scintilla of evidence from which a reasonable inference can be drawn, including as to the supervisor.
What you're saying about that last argument, if I can understand it, it's that the non-discriminatory reason is you really couldn't do your job, and she didn't come back and establish with more than a scintilla of evidence that she could.
She didn't establish that she was retaliated against.
Right.
Once the FMLA expired, her rights evaporated. That's my stagecoach metaphor.
Was retaliated against because that wasn't a real basis that she couldn't do her work.
Right, but the retaliation isn't precisely a failure to reinstate, and the case law is clear on that. It's that her articulation was, we failed to give her this process that would have led to, perhaps I'm overparsing, but she said there was a return to work clearance policy.
There were 2 reasons.
Sorry?
I just thought there were 2 reasons.
Yeah, no, she said, well, I think they get sort of jumbled, and it's very hard to separate them. But her essential point was, there's this return to work clearance policy. You denied me this. That's retaliation. And that purported thing turned out to be illusory. Illusory. In fact, the judge called it a red herring. The judge said, this was nothing but a red herring. I feel I've been misled. This trial only occurred because of this articulation, and it turns out it never even existed. And I believe, Your Honor, that informs the JNOV as well as the new trial.
Okay, Mr. Holtz, to use your Cinderella analogy, it's past midnight, so.
I shall move on in my pumpkin status, Your Honor. Thank you very much.
Mr. Margolis, good morning.
May it please the court, Jonathan J. Margolis for the plaintiff appellant Marie Esler. There is actually plenty of evidence here under any definition of pretext or pretext plus.
Plenty of evidence of what?
From which the jury could reasonably have determined that the motive why Ms. Esler was precluded from returning to her job was retaliation.
So that the fact that she got extended family leave, the hospital, having given her that leave, then retaliated against her for having taken it by
Yes.
firing her.
Yes.
Or terminating her.
The Hodgins and
And that was the theory of the case.
as the case wound up being tried, yes. This was a case that wound up being tried in a way that was not anticipated. I suspect, I didn't do the trial, by either of the parties, but that happens at trials. It's significant, I suggest, that The instructions on credibility that the judge gave were not challenged by the defendants. The instructions on retaliation, on motivation, were not challenged by the defendants. The charge went in without any objection of any significance at all.
So do you agree, however, that the evidence was that your client told the hospital that she would not be able to return to work on February 16th, which was the extended period beyond the FMLA?
I think it's clear from the record that the jury would be warranted in finding, well warranted, that what she told her supervisor, Ms. Sylvia-Reardon, was that on February 16th, she would still have some restrictions. She would have a 5-pound lifting restriction.
But didn't she say she needed 6 more weeks?
To return to her pre-injury status. It's not clear, Your Honor, and she maintained at the trial, and the defendants did not object to this testimony, and she even demonstrated to the jury how she could have carried out the essential functions of administering dialysis. Again, that was not objected to.
That she could bend her wrists and move the...
She could bend her wrists, that she could press, the only thing she couldn't do, and this is in the doctor's note that she presented, which is in the record. I don't have a record citation, but it's cited in our brief. She presented a note in which she said, the doctor said, a 5-pound lifting restriction.
But in answer to Justice Cordy's question, you say the jury could find on the evidence presented at trial that what she said before or on February 16th wasn't that she couldn't return for another 6 weeks. She said, I can't return, I won't be in a position to work without restrictions for another 6 weeks?
To full function. It's actually not entirely clear on the record. There was a reference to 6 weeks in an earlier email. She explained that at the trial. If you look at the record, there is her testimony, which was, came in. The jury was instructed on credibility, that it could take any contradictions that it found into account.
Well, if she was qualified to do the job, why didn't she just come back on the 16th instead of saying, I can't do the job?
Well, Justice Hines, she didn't come back on the 16th because on January 28th, 1 week before her 12 weeks of FMLA would have ended, she was told she could not come back. And the key here is really not whether she could have come back on February 16th to full function or not, because this is a retaliation case. This is not
Can we get to that?
prescription.
Because I'm having trouble reading your brief and understanding precisely what the retaliatory act is that she proved at trial.
Let me try to assist you with that and try to make it clear, and I apologize if we haven't been clear. A week after Ms. Sylvia-Reardon told Marie Esler that she could not come back to work, she sent an email around to the department congratulating Darlene Crecilio on accepting a 40-hour position as a dialysis nurse. Now, Darlene Crecilio, it's all over the record, had started a 3-month program of instruction in dialysis nursing a bit less than 1 month, or just exactly 1 month, before that email went out. So what Ms. Sylvia-Reardon did was she was really faced with a choice. She could bring back an experienced nurse who had some physical limitations, or she could hire full-time a nurse who was not fully trained. In neither case was she going to get a nurse who could perform all the functions of a dialysis nurse, which is what she testified, as Justice Botsford pointed out. That's what she testified was the reason why she didn't let Marie Esler come back.
So you're saying that what she proved Well, to analogize it to employment discrimination, you would say you've got your prima facie case, and I guess, and that what you proved was that the reason given was shown to be pretextual because the person hired couldn't fully function either. Is that
Right.
Is that
It's, retaliation is always intentional, and it's a question of motive. The real question here is not what Marie Esler might have been able to do on February 16th, which on January 28th, nobody knew, and Ms. Esler testified. I said to her, 3 weeks from now, things will, are likely to get better, and they were. We don't know what she might have done, but the real issue here is what was in Sylvia-Reardon's mind.
Well, all right, so Judge Giles, now maybe you're telling me she's just wrong. She says on January 27, 2009, plaintiff advised MGH she could not return to work on February 16th, but she could return in 4 to 6 weeks wearing a splint. You're saying that's not the evidence?
That is not the record.
Okay, so she just
She might,
this up?
she might have, well, I would say that she was,
I would say that's
perhaps
not the complete
misremembered
record.
the-
That's not the complete record, because that's clearly in the record.
There are several things in the record. And one of the things in the record that my brother has adverted to is an email that Ms. Esler sent and some deposition testimony.
All right,
Which
when
was
did she
not-
send the email?
She sent the email on January the 28th, I believe.
Okay, so this is not January 27th? Are we talking about this?
Essentially the same
Yeah,
date.
saying,
And it says that there are limitations. And she presented,
she doesn't say she can't return to work on February 16th?
she doesn't say I can't return to work at all. She says there are limitations. She says, there will still be limitations. The email, it's not as clear as we would like. But
What does she say in her deposition testimony?
She says in her deposition testimony, she is asked, didn't you say in the email you couldn't return from work?
To work, yeah.
And to work. And she says yes, but if you read the email, that's not really what it actually says. And again, the testimony, she explained it at trial. And I suggest that given the judge's instructions, given the failure of the defendants to object, that was permissible testimony, and it was permissible for the jurors to take that testimony and to say that she could have come back in some fashion. But again, the significant issue here, because this is only a retaliation case.
Yeah, that's my concern, so address it. Under FMLA, after the time period is over, they have no obligation to bring her back, correct?
They may not have an obligation, Your Honor, but both the Hodgins and Colburn cases in the First Circuit make it clear that there can still be retaliation.
No, I understand there can still be retaliation, but, so after 4 weeks is up, the person says, I want to come back in 5 weeks, and the employer can say, sorry, we're only obligated to give you 4 weeks, we do not wish to give you 5 weeks. But, of course, we didn't expect this to happen, so of course we don't have anybody ready to do your job in the 5th week, and you're saying that the fact that they didn't have anybody to do her job as she did means that that was retaliatory.
No, Your Honor.
Well, you were focusing on the fact that the person they brought in on January 28th could not perform her duties, but isn't that almost always going to be the case when somebody seeks to prolong their FMLA leave?
No, Your Honor, because it's possible that the employer will wait until they have someone who's fully qualified. And, Your Honor, the employer here did not say, you've used up your leave, that's it. What Ms. Sylvia-Reardon said explicitly, for the reason why she would not permit Ms. Esler to come back was they have to be able to perform all the duties of a dialysis nurse. And then she goes out a week later and hires someone who cannot perform all the duties of a dialysis nurse. And all I suggest to you, Your Honor, you might not think that that is sufficient evidence to convince you of retaliation. But it is sufficient evidence, I suggest, for a reasonable juror to conclude in the context, and given the other evidence that's here, if I may take a moment, Your Honor, there were at least 2 conversations during January between Ms. Sylvia-Reardon and Ms. Esler. The evidence is that in neither of them did Ms. Sylvia-Reardon inquire about Ms. Esler's real ability to do the job. She didn't say, can you do this, can you do that? There was no inquiry at all made.
What was that on the employee or the employer to make that determination? I mean, in other words, did Ms. Esler have to show that she was qualified to resume her duties?
She had to bring back a letter from the doctor, but Your Honor, again, the issue here is Ms. Sylvia-Reardon's motive for not letting her come back. So I think the question is different from whether Ms. Esler or the hospital had to show ability and what was ability. The real question before you is, could a reasonable juror find that there was retaliatory motive?
Well, my question is, whose obligation in the burden production and proof during the trial, who was required to show that?
Well, the burden to show the retaliatory...
Blaming Ms. Sylvia for not digging in and asking questions and satisfying herself when Ms. Esler has already said, I can't do this job.
What I'm really saying, Your Honor, is that the jury could take the failure of Ms. Sylvia-Reardon to inquire about her ability, taken with what she said about having to do the...
So why would she have to inquire if she's already said, I can't do the job?
Because that's not exactly what she said. She discussed that she was making progress. She would need a splint. By the way, what's notably absent in the record is any discussion of this splint or brace and whether she would have to actually use it while she was administering dialysis treatment. There's no discussion of that. I'd also like...
She could come back. Is that what she said? We'd find in the record that she didn't say she can't come back. She said, I could have come back and performed the duties, and I told him that I just can't lift more than 5 pounds, and that didn't really require it. And she established that. And if there wasn't anything in response to that she established that she could do it, and if that was false, that is, there wasn't enough evidence, that's when it falls away.
Well,
but
again...
she did. Is that what you're saying? She did show that.
It's enough, yes, because her testimony has to be taken in the context here as having been accepted by the jury.
So you say we should look to see that she said, I was in trial and I showed him how I could move a dialysis machine. That was really important. And I could get the gloves off very quickly and put them back on, move the splint in 5 seconds, and all those things.
And she said that without cross-examination on it. So, again...
But if the job required more than that and she couldn't do it, and she acknowledged that or didn't provide evidence that she could, then we don't have retaliation, correct?
I do not agree with that, Your Honor, because the question is always, what was in Ms. Sylvia-Reardon's mind? This is not a question of a violation of the so-called prescriptive rights under FMLA, but of the proscriptive rights. You may not retaliate. It may have been legitimate for the hospital to do what it did, but it couldn't do it for a retaliatory reason.
The retaliatory reason you claim is that she took the FMLA leave that Ms. Sylvia-Reardon encouraged her to take.
Your Honor, could a reasonable juror have said in the circumstances, because remember, it was several months earlier that Ms. Sylvia-Reardon allegedly suggested the FMLA leave, You know, the question only is, could a reasonable juror find this? And I suggest that, I mean, the strongest evidence of retaliation comes out of the defendant's own mouth
It's retaliation for what? For having taken?
for
the
having
leave?
taken FMLA leave.
And
That's, so does it go back in time to when she decided to take the family?
The retaliatory motive is presumably has to be present at the time the decision is made.
To take the leave?
No, to refuse her the
terminate.
right to come
That's
back.
when the retaliatory
Yes.
motive is, to retaliate?
Yes. That's the key incident.
is it retaliation if she's angry because she didn't come back within the time frame? Retaliation for taking the leave, or must it be that it's retaliation only if she's angry that she took the allotted time?
Your Honor, I don't know what the jury did. I don't know why the jury did it. I don't, you know, I suggest.
But that's not the issue. The issue is what the meaning is of retaliation, because it seems to me, correct me if I'm wrong, that the retaliation has to be, I am doing this because you took your 4 + 4. You took what I gave you. That is forbidden. But it's not forbidden to say, I gave you these 8 weeks and I am really teed off that now you're trying to get another 2.
That, however, is a jury question as to which of those would apply.
Yeah, but would you agree with Chief Justice Gann, it's 12 weeks, right?
12 weeks.
Would you agree that to say that if your reason is, I'm really teed off because you're nickeling and diming me, we've given you actually more than 12 weeks, I'm tired of this, no. Is that retaliation for
I
taking
think
it?
perhaps that would not be, but that is not this case, because we don't have the defendant saying the reason I wouldn't let her come back was that I was teed off, that she wanted to take extra time. We have a denial that there was any retaliation. We don't have anything beyond that.
Well, inherent in retaliation is that the employer does something that they shouldn't do to you because you've exercised your rights. But here, if it's, as you say, refusing to let her return, they didn't have to let her return.
Well, let me put it this way. One of the things that could have been done is Ms. Sylvia-Reardon could have said, come in next week on February 6th. Let's see if you can do the job or not.
She
Let's see
didn't
what
have
you
to
can
do
do.
that. I mean,
But
what-
Your Honor, it comes down to her motive. The charge was that the question was whether the defendant refused to allow the plaintiff to return to work because of her taking FMLA leave. Because of. That but for her taking the leave.
I'm trying to get you to focus on what the nature of retaliation is. Retaliation means that somebody is disadvantaged in some way in the terms and conditions of their employment because they've exercised their protected rights. And I'm suggesting that it's problematic in this case if the alleged retaliation is something that the employee wasn't entitled to anyway.
Your Honor, again, I would suggest that Hodgins and Colburn talk to this situation, and they make it clear that you can have a retaliatory motive even though the FMLA leave might have expired.
So let's assume that. So then, as I understand, Colburn, you still have to look to see whether the stated reason, which, as I understand what you're saying, is that you said you were coming back, but now you can't. So, okay, so she's had the leave, and they say, and so the employer's pretextual reason is because you can't really do it. Okay, you had the leave, we extended it, but now you still can't. And so you'd have to establish that that's pretextual, right?
Yes,
Show the retaliation piece.
yes.
Okay. So how do you establish that that's a pretext? Because if that's a legitimate business reason, and unless it's false, right?
It's pretextual, Your Honor, because a week after she effectively dismisses Ms. Esler, the same individual, the same supervisor, hires someone who is arguably less qualified.
We only know about that individual that she'd been hired to fill in a gap. She's been filling a gap, so she's going to continue to fill a gap because she's being trained. And that's as compared to a person who says, I'm still in occupational therapy, I still need some time, I know I've got these splints, and with no expert testimony, he says, but I can do this. Oh, maybe not push the dialysis machine, but there's lots I still can do, even though I can't come back when I said. And they're saying, well, I'm sorry, we can't do that.
But, Your Honor, I mean, there is, in the record, there's an email from Ms. Sylvia-Reardon saying that Ms. Crecilio will not be able to come back to perform the duties of a dialysis nurse until April 6th at best, which was about 7 weeks after the February 16th date on which Ms. Esler was going to come
And there's no
back.
end date in the letter that says when the inhibitions on movement would be lifted, when the restrictions would be lifted.
But there is competent evidence, indeed unrebutted evidence, that the restrictions on movement would not have restricted Ms. Esler from at least most of the functions of a dialysis nurse, all the ones that she was asked about, and she was not cross-examined on any other functions and her ability to do those.
Okay.
Again, it goes to the question, first of all, of motive, and secondly, not what we might find were we jurors, but what a reasonable juror could find. And on this record, I suggest that a reasonable juror could find, and 12 of them did find, after several days of trial, numerous exhibits, they asked questions of the judge during their deliberations. They came back and they found that there was a retaliatory motive, and that verdict deserves respect.
Okay, thank you.
Thank you.
Okay.
Carry, carry, carry. All persons